All right. Yesterday, former President Trump was arraigned again, and he had this to say to the press before he jetted back to the safety of Mar-a-Lago. Well, sometimes safety, sometimes the FBI's there. Hopefully, it wasn't there when he got back yesterday.
Well, thank you very much. This is a very sad day for America, and it was also very sad driving through Washington, D.C. and seeing the filth and the decay and all of the broken buildings and walls and the graffiti. This is not the place that I left. It's a very sad thing to see it. When you look at what's happening, this is a persecution of a political opponent. This was never supposed to happen in America. This is the persecution of the person that's leading by very, very substantial numbers in the Republican primary and leading Biden by a lot. So if you can't beat him, you persecute him or you prosecute him. We can't let this happen in America. Thank you very much, everybody.
You can't beat him, you prosecute him. I like and I just have to say, I love the, your case is a joke and your city's a dump. That's basically what he said. I'm out of here. All right, very good. Now, you've heard my arguments on this case, this indictment.
Yes, I have. I'm a loyal listener.
Yeah, and so let's hear some disagreement. And this comes from no less an authority than former Attorney General Bill Barr, who was on with CNN talking about whether or not this is a facially ridiculous case, as George Washington law professor Jonathan Turley characterized it, for example, or not.
Ridiculous on its face?
That's what Turley said. That's not what Barr thinks. But first, there's that matter, and then there's the second question of, even if you believe it's potentially a legitimate case, would you, using your prosecutorial discretion, choose to pursue this case, understanding the larger implications? And that's where Barr started before he addressed the merits of the case. So listen to the question about the legitimacy of the case, but his concerns. Listen to his concerns, and then you'll listen to his legal argument.
Yeah, I think it's a legitimate case. I think, unlike the document case, it's going to have issues of proof. It's a more complicated case. And I think there are some downsides to it. I think there were reasons not to bring it. I've said before, I'm a little concerned about the slippery slope of criminalizing legitimate political activity. I'm worried about moving in that direction, and I'm also worried about bringing this case and the divisiveness that it will bring by highlighting the double standard. Because at the same time this case is being brought, the department appears to have dropped the ball on the Hunter Biden investigation. It's going to be very hard to persuade many Republicans that this isn't political. I don't know if I would have approved the indictment, but in the sense I may have exercised discretion and not gone forward with the case. I'm also concerned about having this case going on during the election and diverting people's attention from the issues in the election. I'm also worried about what the impact is if there are acquittals during the
election. So yeah, there's a lot of concerns there. Barr's all but saying I wouldn't have gone forward with it because of these concerns that I'm raising, both the election interference concern as well as the double standard. As a legal matter, though, as just a strictly legal matter, Barr said this.
As a legal matter, I don't see a problem with the indictment. I think that it's not an abuse. The Department of Justice is not acting to weaponize the department by proceeding against the president for a conspiracy to subvert the electoral process.
I've often said nice things about Bill Barr because I like him. I respect his intellect and his legal acumen, but I think he is categorically wrong here. And one of the blind spots I think Barr has is, institutional. He's a creature of the Beltway. He's an independent thinker. I don't think he's part of the swamp, quote unquote, but I think he pays way too much deference to the institutions because they're important. But in a way that sort of blinds him to how those in charge are undermining their legitimacy, which is why I think he was slow to act when he was Attorney General, and he's slow to come to this to me, obvious recognition that this is absolutely the weaponization of DOJ, FBI, Intel. And it's not just in this instance, it's the manifest weight of the evidence. Prior bad acts should be considered when making such an assessment, and Bill Barr doesn't seem to be inclined to do that.
We're all subject to our biases, but he is obviously subject to his.
Yeah, and one other argument I wanted to play from Barr, which is material before we get to Andy McCarthy. On the free speech argument with Jonathan Turley, spent some time talking about earlier this week. We talked about it in this show because I think it's a serious one. Criminalizing political speech.
Mm-hmm.
Bill Barr is not persuaded that this is a free speech case.
No, I really don't think that's a valid argument because, as the indictment says, they're not attacking his First Amendment right. He can say whatever he wants. He can even lie. He can even tell people that the election was stolen when he knew better. But that does not protect you from entering into a conspiracy. All conspiracies involve speech, and all fraud involves speech. So, free speech doesn't give you the right to engage in a fraudulent conspiracy.
Mm-hmm. Let's get Andy McCarthy's take on that. Andy McCarthy is a former chief assistant U.S. attorney, contributing editor to National Review, author of the bestseller Ball of Collusion, The Plot to Rig an Election and Destroy a Presidency. Oh, my, wait a second. The plot to rig an election. Andy McCarthy could be in some legal jeopardy with Jack Smith based on his book, I think. Yeah. Andy McCarthy, unindicted co-conspirator after the fact, joins us now. Andy, thanks for joining us. Appreciate it.
Oh, it's my pleasure, guys. How are you?
Good. All right. So what about Bill Barr's take that this is a legitimate case to bring, generally speaking, and then specific his response to the argument that this is criminalizing political speech?
Well, like you, I have a lot of respect for Barr, and where I part company with him on this is that I think he's right that all conspiracies and all frauds are proven by speech. But the thing is, you have to have a crime in the first place,
right,
under the fraud laws. And he thinks that the statute that that Smith has invoked here, this conspiracy to defraud the United States, obviously he thinks that that's a valid statute the way that it has been interpreted going back to the early 20th century, where I think they strayed from what the original understanding of fraud is. Fraud in federal law is a deceptive scheme to bilk somebody out of money or tangible property. It's a financial crime. In the early 20th century, you had judges, including the Supreme Court in the 1920s in particular, kind of contort that or expand it so that it was deemed to be a deceptive arrangement that undermined some essential government function, even if it wasn't designed to steal money or property. The Supreme Court, since 1987, has been walking away from that. They haven't taken on a case that talks about this particular statute. The cases that they've dealt with have been other fraud statutes. But fraud is fraud. And in May, they decided two cases where they threw out convictions against cronies of Governor Andrew Cuomo in New York because the government had tried to criminalize something along the lines of what they're trying to criminalize with Trump, which is not a scheme to defraud people out of money or property, but to undermine, some progressive ideal of what good government looks like. And what the court said is, look, if Congress wants to make that a law, they can try to make it a law by passing a clear, non-vague statute. But prosecutors don't get to do that by extending or manipulating loose concepts like fraud and corruption and the like. And I think that's what Smith has done here. So I don't think conspiracy to defraud the United States means to undermine an election. Conspiracy to defraud the United States means to steal money or property from the United States. And I think what Bill is adopting is the Justice Department's longstanding, I think, wrong and dangerous interpretation of that statute, and I just don't accept it. And I don't think the Supreme Court will either.
The other thing about this, I mentioned a bit when John and I were talking about this earlier. This conspiracy was completely open for public review. I mean, what is mentioned in the indictment, the alternate slates of electors, the attempt to persuade Mike Pence to intervene. I mean, we were all debating this on the airwaves in real time as the arguments were being made, as it was being suggested, and so it has the appearance, this skullduggerous conspiracy that was afoot. There's nothing skullduggerous about it. It was open and notorious.
Yeah, I think, Dan, that I've made this point a number of times, especially about the what are called the fake electors, which I really think were contingent electors, not fake electors.
Right.
But what I've pointed out to people is this reads a lot better than it played, right? It reads in a very sinister way when you read that indictment. The way it played out in real time, nobody in America thought that those alternative electors were real. Nobody thought that they had been certified by the states. Nobody thought that their electoral votes counted. My understanding of them, and I think this will come out in court, it'll be very hard to prove that anybody was being fraudulent beyond a reasonable doubt on this. The idea was that if Trump succeeded in one of these Hail Mary passes to get a court or a state legislature to throw out the popular election and refer the matter to a Republican-controlled state legislature, which would then substitute its vote for Trump for the popular vote for Biden. If that happened, then these people stood as ready to be the electors to cast the electoral votes if that contingency came to pass. The problem is no one in their right mind actually thought that contingency was going to come to pass, and nobody at the time thought that these electors were real electors, and the electors themselves thought that they weren't real electors, that they were there in the highly unlikely event that the popular election got thrown out.
Well, and also, sorry to interrupt, it also, and everybody knew this at the time. I mean, if you were paying attention, it's not like there's a big reveal here. There's nothing in that indictment that we don't already know occurred, and to characterize it as criminal, well, that goes back to the argument you made.
Yeah, well, I just think that with respect to the rest of it, I think what they're doing is trying to criminalize a cockamamie legal theory, which to me is even more dangerous than criminalizing political speech, because
why?
Yeah.
If you're now going to tell lawyers that their imaginative legal theories, of which, defense lawyers and Democrats have no shortage of imaginative legal theories. If that's now a felony, as I've told people, when I was a prosecutor, defense lawyers are very creative men and women. If a cockamamie legal theory is now a felony, I could have indicted 5 of them a day.
Yeah, Dan Goldman better watch out if that's true. Yeah.
Right.
So why is it then, if the Democrats have their way, when a presidential candidate cannot even discuss this publicly, what is the danger besides the bollocksing things up in the courts? What is the danger to the republic? What did the founders, the framers, think was in jeopardy as the result of politicizing speech?
Yeah. Well, John, I think this is a really important point, because it seems to me that those of us who are highly critical of what Trump did in the aftermath of the election, and I put myself very much in that category.
Me too.
That is supposed to, in our system, be checked by Congress. You talk about what would the founders have thought. The founders would have thought it was insane to think that presidents and the bad behavior of presidents could be reined in by prosecutors who work for the president. We didn't have a Justice Department then like we have now, but the system that they gave us, the constitutional structure that they gave us, anticipated that it would be Congress, not the legal system, that would deal with presidential misconduct. And I think what you have here is a situation where the political system really didn't hold Trump accountable in the end, and that has not sat well with a lot of people who despise Trump. And as a result, they're trying to use a legal process as a proxy for failing to impeach him. But the problem is the legal process is not a good fit for this. You have to have laws that, obviously Smith is groping for a law. The reason we don't have those laws is not a failure. It's a feature, not a bug.
Yeah.
If you have the kind of laws that he needs to prosecute this case, you would be inviting the Justice Department and the FBI to get involved in every single election, which is precisely what Bill Barr, I think, rightly says we don't want. And we're now seeing the effects of it.
So when one of the arguments goes, and Bill Barr made it as well, that Trump knew he had lost the election. So he knew that he was perpetrating a lie. However, the Carrick files, Bernie Carrick, who was hired by Giuliani to do some investigative work during the clown show legal challenges that Giuliani was a part of. But they were right up until January 6th, the reporting on those files goes, it turned over to Jack Smith, that they were still exploring the possibility of votes that were counted that shouldn't have been, votes that weren't counted that should have been, and all of the other things that they were allegedly exploring and arguing for from November to when Trump left office, frankly, and subsequent to that even. So that's number one. It's how obvious is it that based on hearsay and what he said to Pence and this and that he knew that he had lost. And so that's number one. And number two is, does it even matter whether he knew or not with respect to this criminal prosecution?
Well, I think to answer the last question first, for all the lavish talk about his state of mind and what he believed, what he didn't believe, if you don't have a crime, you never get to what the guy's state of mind is, right? The thing that you've accused him of has to be a crime before you ever get to the mental element. And that's where I think the case fails. But on the broader thing, I can totally understand somebody like Barr, who had direct conversations with Trump and told him that the things that he was raising had been looked into and were wrong. I could understand him being miffed at Trump saying that, he never knew, or,
he believed it was rigged or whatever.
Yeah. But here's the thing. If I were representing Trump, I think, no matter what Bill Barr told him or Pence told him or anyone else told him, Justice Thomas wrote a dissent when the Supreme Court refused to take the Pennsylvania case. Remember this, before the 2020 election? And what Justice Thomas says, I think, is absolutely right, and I'd be relying on it if I were Trump's lawyers, which is we need to take this case before the election, because the time frame after election for trying to litigate and investigate fraud is so compressed that, as a practical matter, if you don't deal with what the rules are before the election, you're not going to be able to figure it out after the election because the time frame is too compressed. And I think what Trump will say is, no matter what Bill Barr told me, and Barr was out, I think, by it was about the early December of 2020.
Mm-hmm.
No matter what Barr was telling him in November or December, I would assume that Trump is going to say, look, there were still unresolved questions, even beyond when the December 14th, when the Electoral College met. And he's going to say that there are even more questions today than there were then. And it was too compressed a time period to make a definitive finding of whether there was fraud or not, as the Supreme Court justice recognized. And in the meantime, Jack Smith's indictment says that we can deduce what Trump knew because some people were telling him there was no fraud, but that's the prosecutor's side of the story. What Trump is going to say is that logic works for me too, because there were a lot of people who were whispering in my ear that there was fraud, and I believed them.
Yep.
And how do you prove that he didn't?
Yeah. Andy McCarthy, former Chief Assistant U.S. Attorney, contributing editor at National Review, author of the bestseller Ball of Collusion, The Plot to Rig an Election and Destroy a Presidency. Thanks, as always, for your insights, Andy. Appreciate your time.
Have a good weekend, gents.
You too. And he joined us on the Turnkey.pro answer line. Coming up at 7:37, end of the encampments, question mark. That's certainly relevant to Chicago. Judge Glock from City Journal, the best name in conservative commentary, Judge Glock. Sounds like an action hero. At 7:37.
73 degrees at 7:32. We're watching Ukrainian sea drones attacking a major Russian port on the Black Sea. They've damaged naval vessels, according to Ukrainian officials.